This lecture we would like to devote on the refugee law in regards to international instruments and documents, and in particularly the Convention of 1951 regarding determination of the status of refugee. So, before discussing the provisions of these international documents, we would like to discuss about the history of refugees that already we have discussed in our previous videos, but would like to make some important reference in regards to the refugees that emerged out of the First World War, and also with people less inclined than before to accept human misery and suffering. With resignation, so profound changes have occurred since the 19th century in the field of industrialization and also in economic and social phases. So new laws were enacted, and in the same way, the state stills the very aspirations which have given rise to refugee law, which is directly in keeping with contemporary thinking in favor of human rights and increased protection of the individual against the omnipotent state. So, in regards to the very sources of refugee law, one we found regarding those international documents and instruments in regards to the protection and determination of the status of refugees, and also domestic or municipal laws. So, refugee law originates both in national and international law, traditional, and also in customary international law. There can obviously be one question of enumerating here, still less of analyzing all the national constitutions and internal legislations of states which make reference to refugees. So the law pertaining to refugees is based primarily on international treaties concluded between a number of states and binds those states vis-a-vis each other, as well as vis-a-vis the refugees they shelter. So we will leave aside the earlier agreements concluded between 1920 and 1943, which were concerned with specific groups of refugees which are now included in the very Convention of 1951 in regards to determination of the status of refugee. And so also it was later supplemented by the 1967 protocol which deals with refugees, however or wherever they may be. It gives a general and universal applicable definition of the term refugee. So, in that connection, also you would like to discuss some other important documents relating to refugee law. So, in particularly before the convention, We found the 1948 Universal Declaration of Human Rights and after the 1951 Convention and the very protocol of 1967. Some other international documents relating refugees are the 1966 Bangkok Principles on Status and Treatment of Refugees adopted at the Asian African Legal Consultative Committee in 1966. So also in 1967, the United Nations General Assembly Declaration on Territorial Asylum is another international document relating to the protection and determination of the status of refugees. So also in 1969, the Organization of African Union Convention governing the specific aspects of refugee problems in Africa was held. Also in 1974 United Nations Declaration on the Protection of Women and Children in Emergency and Armed Conflict was also adopted in regards to the protection of refugees. Also the 1976 Convention, the Council of Europe's recommendations on situation of de facto refugees, which especially implicate persons not recognized as refugees under Article 1A of the Geneva Refugee Convention of 1951. And in 1984, the Cartagena Declaration on Refugees for Latin America and their all successors. That was another document adopted. And also the 1994 Declaration of San Jose, which held on 7th December 1994 for such of durable solutions for human rights and peace building, and also the 2004 Mexico Declaration. It rooted the generous tradition of asylum in Latin America to recognize the principle of just cognate nature of refoulement of refugees. Also the 2014 Brazil Declaration focusing upon internally displaced persons and stateless persons as refugees. And the 1998 Conclusion on International Protection by the Executive Committee of the High Commissioner's Program, the 2001 Declaration by State Parties to the 1951 Convention and its 1967 Protocol to the Status of Refugees. Also the 2004 European Union's Council Directive on Minimum Standards for the Qualification and Status of Third Country Nations and Stateless persons as refugees or as persons who otherwise need international protection and content of the protection granted. And also the 2016 New York Declaration for Refugees and the Migrants. So these are the international documents and instruments which provides not only determining the very status of refugee but also their protection and welfare. So Now we would like to discuss some other important aspects of the convention, in particularly and the international legislations by the nation states. The essential international angle from which we are considering the refugee problem here should not make us forget that in the country of reception, a refugee lives under rules of law which apply to him in the same way as they apply to all other members of the national community. His normal status is that of alien. The status marked ab initio as inferior to that of the nationals of the country concerned. In addition to excluding him as a general rule from the enjoyment of political rights, the applicable law frequently subjects him to obligations of special restrictions which place him in a marginal position vis-a-vis the nationals. So as a whole, the structure of various international instruments, foremost among which we would like to discuss is the 1951 Convention, and in international institutions for ensuring the protection of refugees as United Nations High Commissioner for Refugees does at present time have created the elements of a legal environment whose existence cannot be denied. The main point of for us to note is that the refugee today no longer stands alone, completely at the mercy of the goodwill of the state. So, in regards to that, under the convention, we found the very concept of asylum and its position and place in international documents. So, traditionally, the very concept of asylum is of both religious and civil origin. The privilege granted by the tradition to places of worship as well as to state in case of persons of foreign nationality applied to the fugitives in general, irrespective of the nature of the crime or offense for which they were pursued. Thus, for a long time, ordinary criminals were not as a rule extradited. It was only in the 17th century the various authors, in particularly the distinguished Dutch jurist Grotius, drew a distinction between political and ordinary offences and held that asylum could be claimed only by those suffering political or religious persecution. So, asylum in international law, a different concept, has hitherto prevailed, which makes asylum a right pertaining essentially to sovereign states. The Universal Declaration of Human Rights itself, in providing in its Article 14 that everyone has the right to enjoy asylum from prosecution, in fact, endorses this concept. The original text referred to the right of everyone to be granted asylum But this wording was discarded as not in conformity with the traditional concept of asylum, which instead reserves the right to grant to a refugee. So the very declaration on territorial asylum is even more explicit. Article 1 of the Convention states asylum granted by a state in the exercise of its sovereignty shall be respected by all other states. Clearly evident there is the main concern of states, which is to prevent the granting of asylum although resulting from the exercise of a sovereign right, the principle of which is not disputed for being a source of disputes or conflicts between the sovereign states. And in regards to the reference in the 1951 Convention in regards to asylum, Article 33 on the other hand formally prohibits the expulsion or return of a refugee to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group, or political opinion. So, in regards to that also, we found this is precisely the aim of Article 5 of the Draft Convention, which imposes on the signatory states an obligation to take appropriate measures individually, jointly, or through the United Nations or other international bodies to share equitably the burden of the receiving country. The word burden should probably be interpreted here as referring both the financial effort imposed on receiving countries and to the problems which might be created by the permanent admission of more refugees than could easily be absorbed. So, in regards to asylum, the states, most of the states, they express their reluctance to enter into international commitments in the field such as that of asylum, even though ancestral traditions in the matter corresponds to humanitarian concern, which is now so manifest and so widely recognized, has not prevented some of them from adopting within the framework of their internal or domestic legislation to take measures which amount in fact to recognition of an individual's right of asylum. The implications of these measures are could be discussed in three different stages. So, in regards to the first stage, that any individual claiming asylum or refugee status would not find himself prohibited from entering the territory or should be already there, even in irregular circumstances, would not be expelled from it. If such prohibition or expulsion would compel him to return to the country in which he is or has well founded fear of being prosecuted, the prohibition holds good as long as no decision has been taken by a competent authority on the application. Why this individual with a view to recognition of his status as a refugee. And at the second stage, the procedure for consideration of the application is so organized that it affords the applicant the fullest guarantees against any arbitrary or erroneous decision, and it includes inter alia provisions for avail to a competent authority and for the refugee to be represented in appeal proceedings and in the third stage. A decision that the applicant is eligible automatically means that he is allowed to stay at least temporarily in the territory of the state concerned. These are the procedures in force in countries at present such as Austria, Belgium, France, Italy, and the Federal Republic of Germany, to mention only a few particularly obvious examples, naturally with differing methods adopted to the particular country's institutions. So, the very status of refugees as provided under the Convention of 1951, it is relating to the domicile status, having required refugee status, and thus the first obstacle a person fleeing from prosecution is then immediately faced with the problem of his future. Without friends to guide or advise him, he has everything to learn, if not everything to fear, from a world which is too often indifferent and alien on account of language, laws, structures, and customs conceived for national the country's legislation and administrative machinery are ill suited to the spatial problems presented by such an alien. A set of rules for integration of the refugee into a system where his place is not assured in advance is therefore an absolute necessity. So the Convention of 1951, which defines the minimum status to be accorded to refugees, lists the principal rights which the contracting states undertake to grant them, subject to exceptions related to each country's particular requirements. Grouped under a number of headings, the general provisions, judicial status, gainful employment, welfare, administrative measures. These rights constitute the most comprehensive list in favor of refugees. So, in regards to that, we would like to discuss the domicile status, which is a personal status, is that the country of domicile, whereas in Europe, for example, or in Latin America, the status of the individual is governed by the law of the country of nationality in accordance with the rule already adopted by the 1933 Nansen Convention. The convention provides that the personal status of a refugee shall be governed by the law of the country of his domicile, or if He has no domicile by the law of the country of his residence. So, in regards to that, let us go to the employment accessibility provided to the refugees as under Article 17 of the Convention. It invites contracting states to give sympathetic consideration to assimilating the rights of all refugees with regard to wage earning employment to those of nationals. Such assimilation, which is normal in common law countries, is a privilege elsewhere. If it is not the universal rule, it is fortunately tending to become so. So the provisions under Article 18 and 19 of the Convention of 1951 provides concerning self-employment and the liberal professions. They merely refer to treatment as favorable as possible, and in any event not less favorable than the status accorded to aliens generally, and as such, in regards to the freedom of movement as provided under Article 26 of the Convention proclaims the right of refugees to choose their place of residence and to move freely within the territory of the country concerned. Although the principle of free choice of place of residence is very widely accepted, its application is sometimes hampered by the regulations on access to employment. And as under Article 28 of the Convention, it provides for the issue of a travel document, a specimen of which is included in an annex which codifies and improves on the earlier provisions. It has a validity of 1 or 2 years and is recognized by all the contracting states or state parties or signatories to the convention and by a large number of other countries. And finally, we would like to analyze and discuss naturalization. So, naturalization is the final goal of the international protection accorded to refugees when their repatriation has proved impossible. Consequently, the Convention invites contracting states to facilitate as far as possible the naturalization of refugees. Naturalization is generally regarded not as a right but as a favor which the state reserves the right to acquire and not to acquire to persons fulfilling certain conditions and unable to avail themselves of the provisions of the country's legislation on the acquisition of nationality, either by just sanguinis or by just solely the duration of the period of prior residence also varies from country to country. The average period is around 4 or 5 years, but may be much longer. Quite a large number of countries have agreed, however, in the interest of the refugees, to a certain assimilation period for naturalization process. So, in the conclusion, it could be summed up that a rule of law cannot be judged subtly by its actual wording and purpose. Everything depends on how it is applied. The fact has been confirmed by the United Nations High Commissioner for Refugees' own day to day experience in performing its protection function. Its efforts to persuade governments to make their internal domestic legislation more favorable and equitable for refugees, therefore, have to be accompanied by constant vigilance to ensure that a rule which has been adopted is not evaded, wrongly interpreted, or simply ignored. This applies particularly and above all in such vital areas as the grant of asylum. Although these efforts are sometimes made on behalf of groups whose assimilation may present special problems, they are usually on behalf of individuals. Hence, the great importance in the country of reception of the presence of the United Nations High Commissioner for Refugee representatives who can know the details of particular cases and who can intervene before it is too late. So, in this particular lecture, we have devoted the very instruments of international nature and the very documents which led development in determining the status of refugee and their very protection, and also we have touched the very aspects relating to asylum and territorial asylum and the role of sovereign states and their legislations or the domestic or municipal legislations in determining of affording asylum, and also we have discussed regarding the status of the refugee as per the provisions of the 1951 Convention in relation to the domicile status to a refugee and the employment accessibility to the refugees. So also the provisions relating the freedom of movement of the refugees and the travel documents which should be allotted to the refugees. And finally, we have also discussed the provisions relating to naturalization of refugees and the various domestic and internal legislations of different states in regards to the very requirement of granting nationality to refugees and the very procedure and process of naturalization. And also, we have touched some important aspects relating to the protection of refugees and to accord all kinds of benefits and welfare to the refugees in our conclusion. And in our next upcoming video and lecture, we would like to discuss the very institution and establishment of United Nations High Commissioner for Refugee and its important role in regards to international protection of refugees. And in that connection, we would like to also discuss the various functions of the United Nations High Commissioner for Refugees.